with this is under the UK GDPR, it restricts transfer of personal data, that's name, email, address, biometric information, health data, anything that identifies you and me, to a separate organisation located outside of the UK, unless the rights of the individuals in respect to their personal data is protected in another way, or one of a limited number of exceptions apply. And that's what I'm going to be talking about today. I'm going to be talking about what allows us to transfer data from the UK, talking about the new International Data Transfer Agreement that the UK ICO has now had approved, and as well as the addendum to the EU standard contract clauses. So what I would like to say first is, if you are an international company and you happen to have branches in international countries, obviously, if you're leaving the UK, transfers intercompany, so your office here in the UK to your office in the US, or your office in Australia, is not classed as a restricted transfer under the UK GDPR. So one of the ways that you can transfer data where you will not need to have an international data transfer agreement is where there is an adequacy regulation. So those of you that are familiar with EU GDPR, you'll know of adequacy decisions. Here in our version of the GDPR, we talk about them as UK adequacy regulations. Now, we have adopted all of the EU adequacy decisions, so data from the UK to the European Economic Area or to territories covered by adequacy decisions already. This is the likes of Japan, partial agreement with Canada, transfers to Australia, for example, are permitted. So you can continue to do that data transfer, as is always the case, and you do not need to have a data transfer agreement. So first thing to think about is, when you're looking at your data transfers, where is the data being transferred to? Which country is importing the data? If it's one of these that are on this first slide, you're covered by an adequacy regulation, and you'll want to make sure that your privacy policies reflect that fact. Now, what the regulation also talks about is, if you're not relying on an adequacy regulation, you need to make sure that there are appropriate safeguards in place to allow you to transfer that data outside of the UK. So if you are a large global organization, you could rely on binding corporate rules. You could have standard contract clauses, which is the common way in which data has always been transferred if we didn't have an adequacy decision. Or there are clauses that are specific to you being a public authority. So what I'm going to focus on is the appropriate safeguards and what the UK has actually now put in place and has approved as of this week. So the International Data Transfer Agreement went out to consultation last year. It was set before Parliament in January. There were no challenges to that. So what we now have is two options available to us where we are not transferring data under an adequacy decision. We can use the International Transfer Agreement, or we can use the addendum to the EU standard contract clauses, and I'm going to cover the latter later on in the slide deck. So what the International Data Transfer Agreement allows us to do is to be able to put contractual conditions in place between us and the data importer, the company, vendor in the non-UK EU EEA country, so that it has the equivalent level of protection as we expect under the UK GDPR. And I'm going to talk about what you need to do before you get to this stage. So what the Information Commissioner has produced is a risk assessment. So this is referred to as the transfer risk assessment. So this is the first stage. So you should be considering the risks that are associated with your data transfer. I'm assuming that you all know where your data is being transferred to and you've done all your data mapping. So what this is asking you to do is to assess the risk of that transfer. So what the risk assessment allows you to understand and to evidence, because remember that accountability underpins the 6 principles of the regulation. What it's allowing you to evidence is that you have got a decision that says, yes, you are permitted to do the restricted data transfer, or no, you cannot. And in some cases, you may not be able to transfer the data unless you make some changes. So it's not always going to be a yes. So the ICO state, and I'm going to quote this because I think it's quite useful, that your risk assessment should not look at whether the laws and practices in the destination country are identical to the UK. Rather, your focus should be on whether we share certain key principles which underpin our laws. And this is obviously, we're thinking about security, we're talking about data minimization, we're talking about individual rights and how they are upheld. So this is the key aim of the risk assessment. And this is what you need to overall establish. And then I'm going to talk you through each of the 3 stages that are in the risk assessment. What I'd also like to point out, just in case there's anyone on the webinar that has already looked at the tool, the data transfer risk assessment that the ICO does have still has it in draft format. When I asked them earlier this week, well, have you finalized it? Their answer was not yet. So this is what we have. The draft format is what I'm talking about. I'm hoping it doesn't change, but if it does, we may run another webinar. But at the moment, this is the tool that you can use. And like I said, it's still in draft format. So there are some of the things that you need to consider. So mapping your data flow should include data, not just to the importer in the country, but where do they transfer data to? So do they have any sub-processors supporting them? So you might have a cloud-based system in the US that is using Amazon Web Services, for example. So think about the onward data transfers beyond the data importer, because you will be required to do a risk assessment on that entire supply chain. You will need to establish how the data importer will put in place the agreement and what level of protection they can actually accept. And what we do through the risk assessment is to manage and understand that risk, like we do with any good risk assessment. So what does it look like? Now, the transfer risk assessment is about a 50-page document. It is a beast to read, I'm not going to lie. It is available on the ICO website to download. And what I'm going to talk through is the 3 steps that they talk you through for each individual transfer. So step 1 is to actually, not surprisingly, assess the data transfer. What we need to do here is we need to be thinking about, can you satisfy, now this is on you to demonstrate this, that you've found the answers to this. Can you satisfy the key requirements under the law? So data minimization is, can you evidence that the data you are proposing to transfer, so name, email address, staff details, business contact details, whatever it is, the data that you're intending to transfer, is adequate, it's relevant, and it's limited to what that transfer relates to. So you shouldn't be transferring more data than is absolutely necessary to this third-party vendor or third-party supplier to you. So data minimization, limited, adequate, and relevant. You want to be making sure that you have put in place with the vendor technical and organizational measures to ensure a level of security appropriate to the risk. So this is about the type of data that you're going to transfer. So if you're going to transfer contact details, for example, you might not put as severe a technical onus on the vendor to implement those controls. However, if you're going to put health data, for example, and you're going to store it on a cloud-based solution in the US, what are you going to be wanting to have on that? Are you wanting that to be encrypted in transfer? Are you wanting that to be pseudonymized? So if it was to be intercepted, it couldn't be understood. So based on the data that you are intending to transfer, what are the security, technical, which are the encryption, the operational, which is things such as you'd want the vendor to demonstrate they've got policies, procedures, and training of their staff. What do you want to see it in place? And this is what will form part of the contract. What are the processor obligations? So reporting a breach back to you within 24 hours. Do you want them to be able to be open to you conducting an audit of them? Obviously, the GDPR does set out specific processor obligations and clauses, but what do you expect the processor to demonstrate to you? What's your basis for that transfer? So is it consent? Is it a legitimate interest? Is it a contract? And most importantly, are you being transparent on your privacy policies that you are going to do a data transfer? So you're assessing the need for the transfer. So here are some reasons why the transfer risk assessment may actually not be appropriate for you to conduct. And it's better to understand this early on in the process rather than spend hours upon hours on something that is not relevant. So if the transfer is not suitable, so it doesn't meet Article 5, so these are your lawful basis, this is your security, this is data minimization, this is retention. So it doesn't meet those requirements, you can't transfer the data. If we, like I've already said, it's not suitable to do a risk assessment because actually there's an adequacy decision in place that says the data can be transferred. You are relying on an exception, which actually should say 49, not 4. So you have, it's a one-off transfer and you've got consent, or you have a contract in place to facilitate that data transfer, or the transfer is too complex and too high risk. So you're talking about data that involves vulnerable adults. It might be biometric data, and it's of large volumes, and actually it requires you to conduct a data protection impact assessment before you even consider the transfer. You may also want to consider if you have found a supplier or a vendor that happens to be in a country that has a very poor human rights record, you might not want to transfer your data there, because if they don't respect individual rights and privacy, they're not likely to be able to uphold their contractual obligations in that regard. So, and if you're interested in, well, how do you find that information? How do you know whether or not a country has a good human rights position? The Economist produced a report called the, oh my God, I can't remember what it was. It was the Economist Democracy Report of 2020. If you want a link, I can send it to you. But essentially, it categorized all the different countries in no risk, low risk, medium risk, and high risk. So if that's a link that you would want, I'm more than happy to send that to you, or simply Google Economist Democracy Report 2020 and it should come up. So then obviously, as I've said, the final real checks is for you to then determine, because you're going to have to put this actually into the agreement, is the specifics of the transfer. So who is it going to? So what kind of organization is the importer? Is it a public regulator? Is it an IT company? Is the company going to be a controller? So is it a controller to controller relationship? Is it you sending data to a processor? for example. Who is the data about? So you would have already done this as part of your data mapping. So is it about clients? Is it about staff? Is it about business contacts? What's the type of data that you're sending? Is it special category? So this is your health data, trade union membership, biometric, race, ethnicity, for example. What's the format that you're going to be transferring the data? So is it in plain text? Is it encrypted? Is it going to be pseudonymized? How often are these transfers going to happen? So is it an everyday occurrence or is it a one-off? And how much, what's the volume of data that you are transferring? So this is all information that once you've done this assessment, you can extract and actually put into the formal data transfer agreement. So it is quite a key step at this point in time. So what we then have is once you've assessed the transfer, what we're looking for is whether or not the information, International Data Transfer Agreement is actually enforceable in the destination country. Now, what I am going to say is that I'm obviously providing you the guidance in terms of what this talks about, but if there are uncertainties that you have about the country you're intending to send data to and the agreement that you're wanting to finalize and put in place, you may need to seek legal counsel to make sure that you are in the best possible position in terms of cover. So what you need to do is assess the enforceability of the contractual safeguards. So if you're sending it to a country that has a real poor human rights position, has a high level of surveillance where the government is able to ask companies within that country to give them access to the data, the agreement that you're going to enter into may actually not be enforceable. So what you need to do is satisfy yourself as to whether or not it is enforceable. So if you're going to put contract clauses in place that both parties are going to sign up to, can both parties adhere to that? And like I said, if you're uncertain, you might want to do a bit more of a deep dive into the risk assessment. You might want to consider putting in supplementary measures. Or you might simply decide that the transfer is far too risky, the agreement's not enforceable, and you're not going to do the transfer, or you're going to seek to transfer the data to a safer destination. So like I said, some of the considerations and what I like about the transfer agreement actually is that it's tabulated. It gives you what's good and what's not good. So it gives you an indication of what you can be looking at when we're considering about these questions. So I've only summarized it, but I did like the usability of the tool. It might seem a bit overwhelming, but it does show you, like I said, good and what does not good look like. So what you're assessing now is, does the country recognize the rule of law? And most countries do. Can you enforce foreign judgment or arbitration? Is there, when you look at the judicial system in that country, is there a high level of integrity? And again, I go back to that report from The Economist. It gives you really good insight in terms of the judicial systems within countries. And, are there partial adequacy regulations, such as in Japan and Canada? So therefore, they do recognise a large amount of the UK data protection laws. So if you have concerns that are contractual rights and protections, you really should fill in section 3, which is the supplementary measures that you'll find acceptable to put in place. And again, seek legal counsel to help you with that. So the supplementary risk assessment is to, as all risk assessments, is to assess the overall risk. So if you know what data you're transferring and you know the sensitivity of the data, you'll then be able to again go through the risks. And again, within the transfer risk assessment, it has a nice table that sets out, you know, if it's staff details and it's just contacts, it's a low risk. A medium risk would be details about the individual, photos, for example, and then a higher risk kind of staff data is your medical information. So it sets out a nice table, so it allows you to assess the risk of that individual and that individual's data that you're planning. And can you actually reduce the risk? So one of the reductions in the risks is that you simply don't send health data, or you will want to enforce pseudonymization of the data when it is transferred. So you should really look at the different risks. You may have already done this, and it might just be about revising those risks to make sure that everything has been accounted for. It's not going to be 100% perfect, but do complete this stage. And again, I will repeat it, consider whether or not there's benefit to getting legal advice, especially if you've got legal expertise that are that know particular countries very well and they have acted on behalf of clients in those countries. So some of the types of levels of measures that you might want to put in place, you might want to encrypt the data before it's transferred. And this might be a question you want to ask the software vendor. Do you encrypt data when I'm uploading it onto the web platform? Is it encrypted? Can you apply pseudonymization? So that's you stripping out the identifiable data and making it pseudonymized. Can you put in additional contract clauses that they can adhere to? So that you can feel a little bit more reassured that you have managed the controls that you are putting in place. So what we're trying to determine at this point in time, and whether or not you're able to move forward, is if there is no or low risk to the harm of the data subject, so that's your staff, your customers, your suppliers, then you can move to the final stage of the risk assessment. If there is an enhanced risk of harm, in that maybe that country can have access to the data, use it for surveillance purposes, then you might need to reduce, well, not might, you should really be looking to reduce the risk by putting in extra steps. Now, if you've decided that actually you've assessed the risk, you've determined that the International Data Transfer Agreement is enforceable in that country, you might determine that you want to understand about third-party access. And when I'm talking about third-party access, we've got to be thinking about governments and whether or not they are going to request access to data. So one of the reasons that Privacy Shield failed was because of the surveillance nature and laws that are in place in the United States, and the fact that certain software vendors are party to particular laws which entitle the government to have access to data. So this is what you're looking at. Now you might be like, I don't know the answer to this, I'm not in the best place position to look at that. And again, you might want to speak to an expert in that country and of that laws to say, what can third parties do with my data? So some of the questions you're going to be thinking about is, are there safeguards in relation to data sharing between public authorities? Do public authorities have wide powers to intercept communications and to access data? And can organisations undertake workplace monitoring with no minimal safeguards? Now, you do not need to do this assessment, and you can continue beyond this stage to doing the International Transfer Agreement if you are satisfied that, given the circumstances of the transfer, so it's minimal amount of data, low risk, that the possibility of third-party access, including surveillance, is minimal, or third-party access is a very low risk to the individual. And then other factors you may want to consider at this point is what rights do individuals have? So we have the right under the UK GDPR to have copies of our data. We have the right to have our data deleted in certain circumstances, if I can put my teeth in. Whereas if the country that you're transferring the data to, individuals have no rights, they can't actually enforce them, then again, it will be a reason for you not to use that software vendor or transfer that data into that country. And are there some data protection or privacy laws in place, but there is little to no evidence that are effective. So they might have a data protection regime, but actually it's not enforceable. And then the final consideration is considering the specific circumstances. So if you remember, I said, what are you transferring? Why are you transferring it? What's the mechanism of the transfer? What's your legal basis for transferring the data? Is it only minimal amount of information? So assess whether the circumstances of your transfer is actually going to be of interest to third-party countries, such as surveillance. Because if it's not, then again, you're able to move on from this stage. So what you're in a position now is you've done your risk assessment, and at the end of the risk assessment, you've either determined that yes, you can do the international data transfer, or it's a no. If it's a no, don't transfer the data. I just want to make that explicitly clear. If you can, you have two choices available to you. You have the International Data Transfer Agreement, or you have the addendum to the EU standard contract clauses. And I'm going to be perfectly honest with you. The reality is, if you're already subject to the new EU standard contract clauses, the addendum is going to be the more likely scenario that you're going to be following. The good news about this, it's only 9 pages. It is relatively easy to work your way through, so you're unlikely to have to use the International Data Transfer Agreement. You'll just use the addendum. What you'll have to do is, when you're looking at the addendum, is understand the type of entity that you're transferring the data to. So are you a controller transferring it to a controller? Is it a controller to a processor? Processor to processor, or processor to controller? These are the 4 modules that are set out in the European standard contract clauses. What it also means, and it's a good thing for you, is that you're not trying to manage 2 agreements. You're just managing the one standard contract clause. And what you may find is a lot of your vendors are sending you updates to the standard contract clauses with the addendum to that. So like I said, it's a relatively short document. It's divided into 2 parts. You should be able to pull all the information that you've done in the risk assessment in the first section where you assessed the transfer, and you should be able to populate it into part 1 of the addendum, where you're providing details of the transfer and the module that applies. Now, part 2, you cannot change. These are the actual clauses that make the amendment work for UK transfers. So it's removed EU and replaced it with UK, for example. So you're modifying part 1 of the addendum, you're not touching part 2. So some of the questions that have come up about this is, can the addendum only be used where it involves an EU transfer? And the answer to that is no. So even if the EU GDPR doesn't apply, you've already been subject to the standard contract clauses, you can use the addendum. And that's a good thing, because it means that we're not having to create new paperwork that is unnecessary. Now, if you are not going to use the addendum to the EU standard contract clauses, you then have the UK's International Data Transfer Agreement, which is the UK's version of SCCs. Now, this is in 4 parts. Again, you can download the agreement from the ICO website, and not surprisingly, it's in 4 parts. you have part one, which is, again, you're pulling the information that you have covered as part of part one of the risk assessment. So you're going to be describing what you're transferring, how you're transferring the data, what's its purpose of the transfer. The extra protection is where we talked about in part two and part three of the risk assessment is, are you expecting there to be supplementary measures? So do you need pseudonymization to be in place? Are you wanting to insist on encryption? What are the supplementary measures? There are some commercial clauses that will be introduced in terms of confidentiality, and then there are the mandatory clauses that the ICO have put in there, which are the contract clauses itself. So, like I said, in most instances, once you've done your risk assessment, you are likely to be using the addendum to the EU standard contract clauses. If that's not what you want to do and you've got a new contract, it's UK to a non-adequate country, and you're going to use the International Data Transfer Agreement, again, use the template that's on the ICO website. I would urge you to get legal counsel to review it, because it is a contract that is going to be binding between you and the other party. You want to make sure, I'm not a lawyer, I wouldn't want to put something in place where I'm like, oh, I'm not sure if I've got this quite right. Then the final thing really is, well, when does this all come into effect? Sorry, I flicked 2 slides too far ahead. So what do you need to bear in mind are the following dates. So contracts signed after the 21st of September 2022 will need to use either the International Transfer Agreement or the addendum. So you can't be using nothing. You can't be using the old standard contract clauses that were replaced last year by the EU. So 21st of September, you'll need to use either the updated addendum or the IDTA. All contracts that are signed on or before the 1st of September, which use the old standard contract clauses, so you've not entered into a new one, these are existing contracts, you will need to have amended or replaced versions in place by the 21st of March 2024. Now, there is a slight conflict here in that the EU have stated that all new deals that are using the EU standard contract clauses will need to be in place by the 28th of December 2022. Now, what isn't clear yet is how the ICO are going to cope with that. So if you're using, if you've still got the old standard contract clauses, you'll need to be moving to the new ones and then the addendum on top of that. So on a positive, I would say, contracts that are already in existing now, that are already using EU standard contract clauses, you're most likely going to be using the addendum. If after 21st of September, you are entering into a new agreement with a new contract, you're either going to be using the EU standard contract clauses with the UK addendum or the International Transfer Agreement. So you've got a bit of time, at which point you've then got to the 21st of March 2024 if you are on an existing agreement. So you've got a bit of time to transition. I would only say, please don't leave this to the last minute. I've seen that too often. So I'm now going to come up to the questions, and I can see that I've already got one in the chat box. Now, I know that was quite an intense lot of slides and a lot of information to digest. You will have the slide deck. So in terms of the selected contract clauses modules and selected clauses has 2 options. Could you advise when we would need to use which option? So I need to bring that up. So what I might do is I might, if it's okay, take that question away because I'll need to have the deck up in front of me so I know what I'm looking at. I thought I had it in front of me, but I don't, so I do apologize. So if you're okay, I will take that question and I'll come back to you directly with that, because I don't have it in front of me, so I do apologize for that. Are there any other questions that hopefully I can answer today? If not, I will get back to you next week. Any questions? Any concerns that you might have? I can see some typing going on, so I can. There is quite a lot to look at, but I am happy to have any questions offline with people if you prefer not to have them on this forum here. Like I said, the recording is going to be available. There are some useful law firms out there that have got some really handy tools. The ones that I typically would look at for sure are Bird and Bird and Field Fisher. They typically have some good free tools that can help you with your decision making. Okay, I will take the questions that I've got specifically offline and I'll come back to you because I think they deserve a response that gives me a bit of time to prepare for. So I will do both the two. So the questions I'd be interested in a response to how complete the new form if you'll be sharing information on this. So I'd be interested in the response to how complete the new form. How to complete the new form if you will be sharing information on this. I think you might need to I'm not sure I understand the question. It might just be that I've had a bit too much coffee today. But if you could, I'll take it offline actually, and I'll come back to you on that to make sure I understood the question. Anything else? I feel like how complete. So in terms of selecting your options on the new addendum, it really does depend on the relationship of you and you as the data exporter and you as the data importer. So by selecting the module as is referred to in the EU standard contract clauses, so controller to controller, controller to processor, will be very much what you'll be considering for the new international data transfer agreement. But if you're going to go down the standard contract clauses route, you are looking at those kind of relationships between controller to controller, controller to processor. But I will take that offline, and I'll come back to you on that. Whilst if there aren't any other questions, I've got the two that I know I've got to come back to on. We do have a download of our catalogue. I would say keep an eye out on the ICO website. They are promising more clearer guidance soon. I've gone through what I know is available and what's on the ICO website at the moment, but they've said that the transfer risk assessment is the draft version is what they're going to be using, but if anything changes, I will obviously let you know. If you're interested in joining a best practice group, it's a couple of times a year where you're able to share information about how you adhere to data protection and any current concerns or questions that you have. It's a safe space, and hopefully we give you some practical advice. You can follow us on all of our social media channels. Next month's webinar is going to be learning from data breaches, and there have been some interesting fines that have been issued recently that we will be looking at, and I'm going to be looking in particular at the law firm that was subjected to the ransomware attack that got fined just under £100,000 last month. So that will be one of the ones I look at. Again, I'm sorry I couldn't answer all of your questions today, but I will get back to you. Anyone that has a question afterwards, let me know. Contact me on my email address, which you would have got as part of the invitation. I hope you'll get to have a fantastic day today. Enjoy the sunshine. I hope it's sunny where you are. I'm going to certainly go sit out and soak up some sun rays, and I will definitely be in touch with those that have asked a question. So thank you very much and have a fantastic day.